Good morning, you're Mark Ramirez. Give me just a second. And Mr. Ramirez, this is your initial appearance in cause number 25 DCCR 1362. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 24th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I talked to one, I forgot his name, I'm bad at names, but they said that they were gonna appoint.
Speak
one.
up, please.
They said they were gonna appoint one because my fiancée talked with the DA and with the Keith guy, and something about trying to get a dismissal on the recommendation on my behalf, or to see if I could get that person.
Okay, so who's your girlfriend? Is that Patricia Zamora?
Yes, ma'am.
Okay.
She was outside, but they didn't let her in.
Okay, you do understand that there's a no contact according to your bond at this time.
It was set by the judge in Jefferson County for last month that it was how you say, it was lifted. It was lifted last month.
Who lifted that?
I got the paperwork from the judge.
Well, but regardless of the protective order, there should be a, yeah.
But I'm thinking that's what this thing.
Yes, ma'am, they lifted the protective order.
No, I'm not talking about the protective order. So a condition of your bond is that you not have contact. So there's two different things. There was a protective order that lasted a certain amount of time. That's over, the emergency protective order. However,
So I guess they never told her that either.
well, they don't have to tell her that. It's you. Hold on, I'm looking at some paperwork here. Okay, this is, were you also arrested for driving while intoxicated at some point?
Yes, it's smart.
So the magistration paperwork that's in the aggravated assault case is the DWI paperwork.
And not.
Let me see. No, because it's got the interlock
On
and
the same day.
May 24th. No, 2 different days.
Yeah, I'll have to ask them.
It happened like in the 2 weeks prior in the same.
Do you have the auto ignition interlock device on your vehicle? Okay, if you'll make a note for Christy, I need the magistration paperwork for, can you just have a seat real quick, guys? I want to see the paperwork just to make sure that all the bond conditions are what they need to be on the correct case. So don't leave the courtroom, just have a seat for a minute. Is she here? Okay. Part of what I usually tell you to do, but what I am going to tell you is you probably can hold off on hiring someone. If everything goes well, you adhere to the bond conditions, she takes the class, then at some point, it looks like your case will probably be disposed of without the necessity of you hiring an attorney. It probably isn't a bad idea for you to start looking at least. And obviously, I understand that you guys, it looks like you're trying to work things out, but you're gonna have to not do that for some short amount of time.
Okay, I've been going through the issues, the illnesses and everything, and then I took in her son on myself because the father died out. And I'm the provider of the house. And she don't have a job, she's a full-time mother. And I'm the one that pays for all the bills, all the food, everything.
So here's the thing, it's a second-degree felony. All I know is what you're charged with is serious, and I cannot feel comfortable without more information or some type of hearing. Now, if you want to go hire a lawyer and they can file something to come in and have a hearing where everybody has notice of it, the district attorney can put on any evidence. If she wants to show up, she can. Then we'll discuss it at that point. But the only way to get that done is going to be probably to get, let me see, who's his court appointed? Who's his court appointed? I got it. Mr. Parker? Mr. Parker was appointed to represent you while you were in custody. He is still your court-appointed attorney. Talk to him.
Court-appointed attorney Mr. Parker is still in play. This is your safety net. If you skip this step, you risk missing out on motions or hearings that could change your bond terms.
About all of these issues. He can file something, we can have a hearing, have her here, and then I will consider lifting that no contact. As of now, it's a no contact. So,
So that's what he can do it, that's everything.
well,
I'm just trying to.
nothing's going, listen. You see how many people are in here today? I have that many people every day. I understand you've got a lot of issues. I'm trying to help you out. Talk to Mr. Parker. You have a no contact as of now, period. Step in front of the clerk. She'll give you a reset notice. In clause number 20.
The judge is stressing no contact in both person and communication. This is huge. It's violating it could land Mark back. In custody immediately, think about how restrictive this feels, even outside the courtroom.
25 DCCR 1362. That is the aggravated assault with a deadly weapon. And if there was not already a condition of your bond that you not have contact with the complaining witness, which I believe there probably was, then I am imposing that condition now. I understand she's out there. Y'all need to figure out different places to live, different things to do until your case is resolved. Do you understand? That means no contact in person. It also means no communication. If she wants to discuss with the assistant district attorney or the district attorney an affidavit of non-prosecution or things like that, she needs to do that separate of you. You need to still go.
Notice the strategic reset here. The judge is giving time for a lawyer to be hired, while also accounting for procedural delays like the options class in January. This is courtroom logistics in action. Sometimes it's about patience as much as compliance.
Get an attorney.
So, she already did talk to the district.
Okay.
January the 8th, she starts the class.
She's going through the options class. Okay.
And that's why she told me that this court date was supposed to be.
Well, nothing gets dismissed until she completes that class. Okay, and so what they do is she goes through that class. If she still feels that that is what she wants to do, she will let them know that, and then that happens after the class.
Okay, so I'm here for you. I had a good job, and with this case pending.
Okay, the case is, there's nothing I can do about the case pending. So your case is pending until it's resolved one way or the other. If that's, I understand, and it's also the time of the year where things go a little slower, like the options class isn't being offered till January and things like that. None of that changes what I'm going to set as your bond condition, which is the no contact order with her, okay? You need to, I'm going to reset your case to give you some time to see if you can get someone hired. If you get a lawyer hired before the next court date, bring the reset notice that you get today. They'll tell you what to do. If you're unable to hire someone, you need to talk to at least 3 lawyers and then bring me who you're talking to and we'll discuss your options. And then it might just take a couple of resets of this. If she goes through that class and the case gets dismissed, then you may or may not really need one, but I want you to be working on it just in case.
So I'm gonna ask if you did hire one, and it does get dismissed all I know that.
That's between, well, and so I typically wouldn't say that this, Ms. Malfino, do you guys have a way to check and confirm that someone has at least signed up for an options class in January?
Yes, ma'am. What's the
It's,
name?
what's her name?
Patricia Zamora.
Patricia Zamora on a January 8th. If you'll just double check that for me. Okay, have a seat again. Okay.
And